I salute you all. Thanks for being on. And today's topic or today's course unit, you are under land law. And the topic that we are going to look at, or the topic that we are emphasizing on, is the topic of conversion. Conversion of leases to freehold. We are converting a lease into a freehold. How can a lease be converted into a freehold? Let me hope at this point, when you are hearing me, you can differentiate what is a lease and what is a freehold. You get? So basically here is the applicant is trying to change his lease into what? A freehold. You get? So bear in mind that the grand constitution or the grand norm, which is the constitution, is the authority that we start with. When you read article 237 clause 5 provides that a leasee or someone in possession of a lease form of tenure, ownership of land in form of a lease, can convert his land into what? A freehold, provided is a citizen of what? Is a citizen of Uganda. So even if you relate to even section 28 of the Land Act provides that for someone to transfer his interest or transfer his lease into a freehold must be a Ugandan citizen. What do I mean? Basically here what you have to bear in mind, or what you have to put in mind, is that a non-citizen cannot hold or cannot own land permanently. He has only one form, which is a lease. You understand? It gives a period of 2 years to 99. Those are non-citizen. But for a citizen of Uganda, you can own under mine, you can own under freehold, you can hold the land in any form that you feel like. But for a non-citizen, you are specifically, and you have to own land only under what? A lease. That's why here they say that if you are to transfer land from a lease into a freehold, you must be a citizen of what? A citizen of Uganda. You get? So put that in mind. Then when you look at the transfer of land, or we are looking at the conversion, is basically here it is also made in form of what? Of an application. But here the application is made to the what? Is made to the district land board. You get? When we read to section 60 of the Land Act provides for powers of the what? Of the board. You get? Section 60 of the Land Act provides for the powers of the board. So here the board is the one that must take what? Genuine care and genuine recommendation in this what? In this conversion. You get? So the board must be satisfied, which is the district land board. That's the board that I'm referring to, the district land board. First of all, it must make sure that the lease was valid. What do I mean by that it was valid? You received that lease through good terms or good lines in accordance with the provisions of the statute, or the provisions of the law, or the provisions of the Commission of what? Of Lands. The lease that you want to transfer into freehold must be valid. So put that in mind. That is one of it. It must be valid. Secondly, on the lease, or the lease that you are trying to change, there must not be any customary tenant at the time you are granted that lease. You understand? At the time you are granted that lease, there must not be any customary what? Tenant. What do I mean that? Well, these customary tenants that occupy on the lease realize that they have a security of tenure. And if you're trying to change the land into a freehold, basically it's like you are evicting them indirectly. That's why the district land board must satisfy itself before recommending you to get a certificate. It must make observations to ensure that there is no any customary tenant at the time of the grant of what? Of the lease. So put that in mind. And also bear in mind, nevertheless, you can also be with the lease where there are customary tenants, and you can also convert it regardless. Here they say that if at all those tenants are there, those customary tenants are there, they must be fully what? Compensated, following the provisions of law. You understand? Those customary tenants must be compensated. What do I mean in this perspective? Remember, a leasehold or a lease tenure system, they give you possession of land for a particular period of time, which means most so for you must have the purposes, they must be developmental compared to the terms and conditions that you sign that lease agreement. So basically, these tenants are always there because you are not the owner, you are just having possession. So the other ones are always there. So if you are trying to transfer a lease into freehold, basically you are calling for exclusive ownership of everything on land. That's why they say that the district land board must make sure that you compensated those tenants, those customary tenants, they were fully compensated. And another thing, what you have to know, or the district land board, what it must make sure is that the district land board must make sure that the lessee must make sure that the lessee is the one that was occupying that land on the lease. It must make sure that the lessee complied with all the development conditions of the lease. Remember, in Uganda, a lease is provided, it is given under condition. It must be developmental. The condition must be developmental. So when you are transferring this lease into freehold, basically you must make sure that you complied with the development conditions that were in the lease agreement. You understand that you signed the lease agreement. You must make sure that you complied with the development conditions. So the district land board must make sure that you did what? You complied. So bear that in mind. And also when we relate to when you go to section 28, subsection 1F of the Land Act, you get, here they say that, here they put in mind that, or what they focus on, or what they put in mind is that there cannot be conversion if at all the land exceeds 100 hectares. They say that there cannot be a lease if the land exceeds 100 hectares. What do they mean? But they say that it can be there unless it is in the public interest. So basically, for you to convert that land into a freehold, it must not exceed 100 hectares unless it is in the public interest. What do they mean by public interest? When you are forming their roads, what and what, among others. For public interest, when for example, government oriented, anything that government does on land, it is more so public interest. So here they say that there should be no conversion if the land exceeds 100 hectares, unless it is in the public interest. But here they say that when you follow section 28, subsection 2, section 28, subsection 2, for it says that if at all the district land board approves the land that is exceeding 100 hectares, if at all it approves, you understand, the conversion will only be valid, you understand, until the applicant pays the market value. Until the applicant pays the market value. What do I mean by market value? This market value, it is like the new interest. It is the new interest on that particular piece of land, but it is determined by the chief government valuer. Again, government has that chief government valuer. So you must pay that market value, which is the new interest, that is determined by the chief government valuer. You understand? Following section 28, subsection 2, so bear that in mind. The onus is on the district land board. You get? The conversion will only be valid if at all you pay the market value, which is the new interest determined by the chief government valuer. You get? But however, they say that if at all the conversion was made when the land didn't exceed 100 hectares. So basically, you are not actually put to pay this market value of the new interest. If at all the land didn't exceed 100 hectares. So put that in mind, or bear that in mind. You get? So, and also basically here, for this conversion under the leasehold is determined by the RTA, the Registration of Titles Act. You get? And here we realize that it is the registrar. When you read section 28, subsection 4 of the Land Act provides that the registrar endorses on the lease certificate. You understand? He endorses on the lease certificate by putting words converted. He puts the words converted to freehold. And they are put in quotes. These are the words that are endorsed by the registrar, converted to a freehold. You get? That is section 28, subsection 4. He puts these words as endorsement. He endorses the certificate. Certificate of a what? He puts the words on the lease certificate. And also when you refer also to, when you continue still under section 28, whereby a sublease automatically turns into what? A lease. You get? And also it puts what? Converted to a lease. If at all that land had a sublease, that sublease turns into what? It is automatic, for it doesn't need an application. It turns into automatically. You understand? It turns automatic. That a lease, it is converted to what? To a lease. Where there is that lease, sublease agreement, it puts those words as endorsement. That is the registrar, or the commission of what? Registration. Who is the commission of what? Land registration. So bear that in mind. So that is the process of how a lease can be converted into what? A freehold. Those are the key steps or the key ingredients that must be considered for you. For you to do what? For your land to be freely, or to be wholly what? To be wholly what? Be wholly converted into what? Converted into a freehold. So, thank you very much. Thank you for listening.